Thank you for this very warm introduction, and it's really a great pleasure for me to be here today. I guess the legacy of Emmanuel College is a great setting for inspiring these new ideas on the new frontiers of fair use. And I'm particularly excited to share my thoughts on copyright limitations and exceptions and on access to knowledge in this particular moment of history. We live in times of tectonic social and political changes. Much of the recent public debate on these political changes and the rise of new political forces has focused on social media and the role of Facebook, Twitter, Google, YouTube that are being accused of at least partly responsible for some of these political changes, the decline of truth, disturbing the political process, introducing fake news, and the failing of the policing against some of the bullying and the distribution of inciting materials online. This may all sound familiar to copyright scholars. Similar allegations were actually raised against online intermediaries back in the 90s, where right holders were claiming that they should do more in order to prevent piracy online. But policymakers were concerned about making online intermediaries more responsible for combating online piracy, and that is because they saw the link between the fight against piracy and some risk to freedom of expression and the limitations on various speakers online. So policymakers, aware of this type of risk, developed a legal regime that sought to balance between copyright protection and freedom of expression by keeping online intermediaries immune from liability in exchange for them taking down potentially infringing materials that were originated by the users. Copyright law was therefore at the forefront of legal enforcement online in a way that shaped the information environment as we know it nowadays. Two decades later, it's probably time for us to look back at this experiment and ask ourselves whether this was successful. To some extent, the privatization of justice and the rise of algorithmic enforcement that we see nowadays is a result of this policy of the DMCA and in Europe, the Electronic Commerce Directive. And these developments set new challenges for copyright and freedom of expression. It is this new type of governance of copyright online that I want to focus my talk on today. The challenge that we are facing is how to preserve this delicate balance between copyright, access to knowledge, and freedom of expression in this privatized environment of enforcement. Limitation and exceptions to copyright seek to strike this balance and in various regimes use different legal frameworks. I'm going to talk about fair use, that is indeed an American doctrine. Yet the future of fair use is important not just for copyright law and copyright protection in the United States, but also outside the United States, In countries such as where I come from, Israel, that has been following fair dealing for quite a while, until 2007, when we switched to the doctrine of fair use. But fair use is important also in countries that never adopted fair use and don't have any plans to do so. And that is because, to some extent, American copyright law has been exported to other legal regimes by the implementation of American copyright law by online intermediaries, such as YouTube and Google and Twitter and Facebook. And since they comply with that law, it really matters whether fair use could survive some of the digital challenges. So the argument I'd like to make to you today is that even though fair use has been significant for balancing between the rights of copyright holders and other interests the society would like to preserve, its practical significance is now in danger. And the reason is that fair use as a legal defense, which could be raised in courts against the allegations of copyright infringement, might be largely irrelevant in the digital era where enforcement is being done automatically by algorithms. Fair use may remain important as a legal doctrine which enables the court to adjust the law to accommodate new technological changes. But with the rise of what I will describe as robo-notices and algorithmic copyright enforcement, the importance of fair use and other exceptions and limitations is actually withering. So what I'd like to do today is actually to describe this shift to from copyright enforcement under the DMCA and the European e-commerce directive, the rise of what is called ADM, algorithmic decision making. This is actually great initiatives because ADM would stand for automated decision-making, algorithmic decision-making, and also autonomous decision-making that is a new generation of algorithmic decision-making. We will talk about this a little bit later. I'll explain briefly why I think this shift is putting freedom of expression in danger, and then I will introduce the notion of fair use by design and explain a little bit how I think this type of idea could actually create new types of challenges for the legal system. So we live in times of great contradictions. On the one hand, we have unprecedented access to copyrighted works. We can instantly access an infinite selection of movies on Netflix, browse almost every publishable book on Google Books and Amazon, and listen to all-you-can-eat music on Spotify. At the same time, however, much of the access that we used to have during the 90s and probably the beginning of 2000 is now protected by paywalls. This holds true for commercial content, but it also holds true for user-generated content that is hosted, facilitated, linked to, and connected by online intermediaries. Consequently, when we think about access, much of the access to content that is made available online is shaped by the design, the business models, the technological measures that are exercised by these online intermediaries. Mega platforms are shaping what is become available, which content could be shared, how we can share content, and which content would be filtered out before it is even uploaded, or blocked after it is being uploaded, or removed upon a notice from the right holders. What is really interesting, and again, in this moment of time, is that we have these mega platforms that are not only responsible for facilitating access, but also responsible at the same time for implementing copyright enforcement. Again, the DMCA and the e-commerce offer these online intermediaries the limited immunity as long as they take down materials expeditiously upon receiving a notice from the copyright holders. And this immunity was definitely looking back at the past decade or so, this type of immunity that developed both in the US and in Europe was definitely one of the most important factors behind the flourishing of the internet, the innovation, the type of free speech and economic flourishing that has come with the internet over the past 2 decades. Now, the safe harbor regime has actually generated huge volume of notices that are being served to online intermediaries. And as a response, online intermediaries has automated their own system. So I think that when we envisioned the notice and takedown at the end of the 1990s, we thought of right holders writing a notice, sending it to the intermediary receiving it, thinking about it, and then removing the infringing materials. Whereas now what we have are robots on both sides. So robots are crawling the internet, identifying materials, sending automated notices with thousands of URLs to be removed, and then these requests are received at the other side by another robot that is able to simply remove or block or disable some of the links to infringing materials. And so if we look at the data coming from Google, for instance, Google just published last July 2016 a report where they indicated that in 2015 alone, 558 million notices were filed with Google under the DMCA, requesting the removal of URLs from Google search result. And if we just look at the data from November of this year, we can see an enormous number of URLs that need to be removed. We actually held a study of this system of removal requests, and I will show you some of the data that we had regarding these notices. But just to make sure that we remember before that along the lines of this notice and takedown system that was established by the DMCA, some of the players, and YouTube is a classic example, have developed what is called the DMCA Plus voluntary measures, where they actually offer as a business some removal services that go beyond the takedown of infringing materials and actually introduce these extra services such as filtering. The end result is that the notice and takedown and these voluntary measures of filtering and takedown and stay down, making sure that whatever it was uploaded will never come up on the system again, actually turned this legal regime using online intermediaries into an effective cleanup system for the web, so that a lot of things routinely are being removed. And so in the empirical study that we conducted in Israel, we systematically analyzed and coded 10,000 notices. It's a huge amount of notices. Removal requests that were served with Google for removing allegedly infringing URLs. One of the interesting findings in this study was that most of these notices had nothing to do with copyright. And so, in fact, only 34% of the removal requests in this study involved copyright allegations. The rest, 66% of the removal requests, were actually the sort of requests that you can file in Europe, but not in the US and not in Israel, that are the type of right to be forgotten requests. So the type of request to remove links to materials that are defamatory or that compromise the privacy of people. So that was the first striking finding of that study. The other was that 65% of these notices were actually filled by a signal entity. We don't know who is behind that, but we have analyzed this as 65%, approximately 6,500 notices that were filled by a signal entity, which tells you how easy it is to manipulate a system of that sort. Now, if you wonder whether this is an Israeli finding that only characterizes the situation of notices served with URLs connected to the .il, right, to the Israeli websites, then you may be surprised to find out that a similar study that was conducted using the same methodology by a team of researchers at the University of Berkeley actually found very similar findings. So the study identified, again, a signal entity, this time Ella Miller, who was responsible for more than 53% of the notices that were served to Google. I guess these findings are showing the great potential for misuse of a system of that sort that lack any judicial oversight, right? And so the question is, what do we do with this legal regime that actually takes place sort of behind the veil of code? We don't have any access to the type of considerations and legal processes that are happening in these automated systems. How do we make sure that algorithmic governance of that sort, the communication between the robo notices system on the one hand and the algorithmic decision-making of online intermediaries on the other hand, how do we make sure that this system actually serves the purposes and goals of copyright law? And one question, of course, among others, is whether fair use still matters. There are a few studies on that, but not that many. So one of the studies by Jennifer Urban at the University of Berkeley that I've just mentioned actually found that 1 in 14, about 7.3% of takedown requests raise potential fair use claim. But in fact, it's really difficult to study, or systematically study at least, the absence of fair use, especially because we don't know what are the materials that are being filtered out before they are even being uploaded, and what are the materials that people don't use or upload because they're not, they're not even there, even though they are might be protected by fair use. So it's hard to study this systematically, but there are a few anecdotes of removals and blocking of fair use materials that could give us a sense of what it is that we're missing by this algorithmic enforcement. So one of the most, I guess, famous examples, which goes back to 2007, is this little baby lens that where in 2007 his mother, Stephanie Lenz, took a 29 seconds video of him dancing in the kitchen to the music of Prince, the late Prince. So Prince is no longer with us. And this baby is still with us, but is no longer a baby, I guess, because this is a case from 2007. It's probably this kid is in college, maybe going to college here. And but the case has not been decided yet. It's still waiting for a decision, even by the Supreme Court of the United States, still in the pile, so maybe will be decided finally this year. The appeal court actually held that this was fair use, and one of the questions that we will come back to is whether the right holder had to consider whether it's fair use or not before filing the notice. Another example, more recent one, is those Samsung Note 7 phones that we cannot take on airplanes that were used by some of the gamers to symbolize explosive material. So instead of bombs, you would put this in the game, and Samsung was not really happy with this and asked the removal of this from the games. Another example is from my colleague at Harvard now, Professor William Fisher, who is teaching copyright law, and in one of his classes that was videotapes and uploaded on YouTube for distance learning. So this is like a 24-minute session where he plays 15 seconds or about 45 seconds of a song, from which 15 seconds were potentially infringing. This was taken down from YouTube. Of course, this was done for educational purposes and would be considered fair use under American law. I lost my presentation here. Maybe this is Big Brother, right? Ooh. This is not to be completely... all right. We need to be more coordinated. There we go. All right. I think it might be. Are we in like current? Yeah. Thank you. To move to more political context, so that it's not just for interesting for copyright lawyers, but also for those interested in some politics. So this is an interesting example of a very controversial movie, The Innocent, not a great movie, by the way, that is called, but very provocative, The Innocence of the Muslims, that was uploaded by a person in California a couple of years ago and provoked violence demonstrations around the Middle East. This was removed in many countries again by YouTube, except in the United States, where actually YouTube mechanically refused to remove the movie and right holders. In that case, that was an actress, brought it to court. The court held that it had to be removed, and later on changed the decision of the Ninth Circuit was reversed by the Ninth Circuit, again, where this movie was uploaded because there was no copyright infringement. And in this maybe political spirit, maybe the most troubling example is an example where a speech by the former President Obama was removed by a request, by the way, that is really interesting, United States Department of Homeland Security. So lots of anecdotes, and the question is what we are seeing here and what could be done about it. So the DMCA, that is actually more detailed in the legal regime that it constructs, had a few safeguards against this. One safeguard was to offer the originator of the work to file a counter notice once a removal request was filled. So this mechanism is actually not being used very often. In the case of search engines, it's really problematic because you don't get a notice, because you don't know, you can't know that your website has been removed from the search result on Google unless you actively look for that. But there are also some procedural barriers. It turned out that it's really difficult for end users, like the average creator of user-generated work, the average teenager that would upload something to YouTube, like a remix or a mashup, to actually understand what's in the notice and actually file a counter notice. It also becomes risky. For instance, YouTube is warning the users that if they file a counter notice, their data is going to be available to right holders, and actually some right holders has made this data public, and this data has been used to harass some of the counter notice filers. And so, as a matter of fact, in our study, for instance, there were 0 counter notices, and other studies, empirical studies that were looking into this regime have shown that very little use of this type of procedure. Filing a counter notice could also be risky in the sense that if you misrepresent in the counter notice that the rights are yours or that you are entitled to use the materials where there were a removal request, then you might be liable for damages, which actually brings me to the second safeguard under the DMCA, where in fact in the United States the policymaker thought it would be a good idea if anyone that misrepresent under the DMCA when they file a notice for removal of infringing materials, if they misrepresent, they might be liable for damages. So when we look at this legal arrangement, we see that any filer of a notice under the DMCA has to consider in good faith that the materials are not authorized by the copyright owner, its agent, or by law. And actually, in the Lance case that we've just seen with the dancing baby, the court held that that the language of the statute that require that a copyright holder will consider whether a use is authorized by law, mean that copyright holders have to also consider fair use, because fair use is not simply a legal defense, but actually defines a right to be using the materials that is defended by law. So if we look at these safeguards, as I said, these were not very useful so far in order to restrain some of the overuse of notices, and without any further safeguards, what we see is actually copyright law changing its default, so that if copyright materials were in fact available, and unless proven infringing in court, nowadays materials that are detected by algorithms would be removed unless the originator, or usually NGOs that would pick up a case of that sort, will be able to prove in court that in fact the use is legal. So when we look at the legal duty that was considered by the court in the case of Little Lance, the dancing baby, we see an attempt of the Ninth Circuit in the United States to, at least to some extent, tilt back the balance in copyright and bring fair use into life by requiring right holders to consider fair use. But in fact, when we think about the volume of notices and the practice of searching for infringing materials by using algorithm, we cannot conceive of a situation where fair use would be considered by human beings, unless we think of a system involving click workers around the world looking into the massive volume of materials and trying to identify fair use before issuing a notice. And therefore, one of the questions is whether we could introduce some automated decision-making that would take care of fair use considerations and would help us tilt back the balance in copyright in a more meaningful way. So the idea is whether we can introduce fair use by design. When we talk about fair use by design, this is not a new idea, of course. Regulation by design, law by design, is probably 20 years old, introduced first by Professor Joel Reidenberg from Fordham University, and later on in a very famous book by Professor Larry Lessig from then University of Stanford, now Harvard University, describing how law could be implemented by code, and how code, as in algorithms, is actually regulating behavior. There is a lot of literature, not in law, but also outside law. Scholars such as Professor Helen Nissenbaum or Batya Friedman, that were talking about values in design, describing the way in which systems regulate behavior and ethics. Privacy by design was introduced actually first in Canada by the Privacy Commissioner of Ontario, and actually may become now part of the European Union new privacy directive. To what extent the UK is going to be part of it, I know I can't tell. And a question is, of course, whether we can envision something similar for fair use. So, for those of you not familiar with or that don't remember the fair use considerations, this is a fair use doctrine. So, in order to claim fair use, or to accept a claim of fair use, court has to consider these 4 factors. That is the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion that was used, and of course the effect of the use upon the potential market of the copyrighted work. Programming these 4 factors would require, first of all, translating fair use consideration to a set of algorithmic instructions that could then be executed by the algorithm, and then writing them in any programming language. Now, some fair use considerations could be relatively easy to automate, such as the amount copied, right? It's probably, algorithms can do it better than humans. But how would we automate a requirement such as the purpose and character of the use, or whether a use was transformative? Actually, there are a few ideas about that, but skeptics of fair use by design believe that fair use doesn't fit the automation that we are considering here, since it involves some complexity and discretion in weighing, in analyzing and balancing between the 4 factors in light of the purpose of copyright law. Now, a lot of the concerns that are now raised in the literature regarding the automation or the regulation of fair use consideration and the limits of algorithmic fair use overlook, I believe, some recent developments in AI and in machine learning. So artificial intelligence is already applied in very sophisticated contexts. Physicians are using algorithms to guide diagnosis. Banks use them to decide who should be given a loan. Security agencies use AI to identify risks. Lawyers use them to perform due diligence. And even courts rely on algorithms in sentencing, using scoring of offenses based on the risk and the risk of offenders to committing future crime in determining whether they should be released or not. So artificial intelligence is actually applied in contexts which are far more complex than fair use and may involve critical issues of life and death, health, financial risks, and national security. Because fair use might be difficult to explicitly program in just the way that I've described before regarding the amount, machine learning and artificial intelligence actually may offer a better solution. So when we think about using artificial intelligence system for fair use by design, we actually require systems of that sort to face a very similar challenge that they face in other contexts. That is, differentiating between 2 types of groups, one of infringing materials and one of fair use. Artificial intelligence systems and machine learning capabilities could enable algorithms to learn patterns of fair use instances. Algorithms could be trained using existing core decisions to make such determinations. So such training could be either supervised and depend on some of the studies that we already have, for instance, in American scholarship, empirical studies on the parameters and considerations of fair use, studies that were done by scholars such as Professor Boyton Beebe from NYU, Professor Pam Samuelson, that I heard was here, and Professor Neil Nathanael, looking at the different parameters and different ways it was assigned to them by courts. But the training of such systems could also be unsupervised, allowing the algorithms to discover clusters of considerations and facts that actually became the basis for the decision that held eventually fair use. Machine learning capabilities would make sure that systems would be up to date, and the classification that is determined by systems of that sort would be applied by the algorithm on an ongoing basis and would change as it receives new decisions with new data patterns. So such procedures are unlikely to be error-free, of course. But they could definitely raise a flag. But this is actually the situation that we have with robo-notices, right? So these systems of robo-notices that I've described to you before are actually implementing some discretion by algorithms. They're actually making decisions regarding a standard or a principle that we know in copyright law that is substantial similarity. They define by code what would be considered similar enough in order to trigger a copyright infringement notice. So introducing a similar a similar system that would not be of course, free of any error, but could raise a flag on the side of fair use, could actually tilt back some of these balances. Some cases, after raising a flag of that sort, would require further analysis, so that algorithmic fair use would involve this type of two-tier analysis, so that you get a notice, and then fair use would be implemented by the algorithm before issuing a notice. And then in case of doubt, when the fair use analysis is less clear, or the scoring of a fair use determination would be lower, it would have to be would be forwarded to further consideration by humans. And again, I want us to keep in mind that human review by judges, as we know it nowadays, would be kept for like the for the special occasions. I mean, most reviews would be done by click workers, as they are be done now for inciting materials, for offending materials of other sorts in social media as we know it. Now, to some extent, the original decision in Lens, again, the little baby, dancing baby case, actually envisioned a system that would enable some algorithmic consideration of fair use, and the court actually implied that could be done automatically. Now, interestingly enough, this language was removed from the final decision of the court, and so in the United States, the Ninth Circuit published the original decision in the fall of 2015, and in March, exactly March of last year, they published a new decision where this language was deleted. It's the same decision, no change in the ruling, but this language was the little. When we think about applying artificial intelligence and machine learning for deciding fair use, we need to think about some of the new challenges. A system of that sort does not translate fair use consideration in a way that a court could actually oversight, right, and ask whether you considered, you took into consideration all of the factors that are listed by the law. But we need to come up with new ways of judicial overview of systems of that sort to make sure that they come up with some reasonable outcome. So if we rethink some of the ways in which we implement legal oversight of automated or algorithmic decision-making of fair use should scrutinize whether the algorithmic implementation is reasonable. So rather than making a substantive analysis of whether the outcome is right or not, or whether this is fair use indeed or not, we should actually look at whether the process was reasonable, or whether the outcome is reasonable, whether the system, what is the error rate of that system, to what extent that error rate of a system of that sort is reasonable, and if so, that could be considered a system that could be used but courts and policymakers would have to decide what would be a reasonable error rate or what would be a reasonable implementation of fair use. And that, if you think about it doctrinally, is a big shift for law, because we tend to think about fair use analysis as an analysis that should be implemented on a case-by-case basis, whereas the type of analysis that would be done by courts when they oversight these type of systems would be actually ex ante, right? Right holders would want to know before whether they could rely on this system before issuing a notice, and potential infringers would want to know whether a system of that sort is a system that actually taken appropriate care of their right. So just in terms of conclusion, fair use by design, in my opinion, is really a must in an era of algorithmic enforcement. The need to develop such tools is necessary in order to tilt copyright balance back to its origins. And fair use by design may also carry some additional benefits. If algorithms become a legitimate measure for identifying non-infringing use, they could also be applied in other contexts. So, for instance, if we think about the context of the educational sector, where librarians or administrators of schools, such as this, have to take into account fair use or fair dealing in advance, if they could use a system that incorporates some of the first cut of the fair use or fair dealing, that could create a lot more space for fair use or fair dealing, the exercise of fair use or fair dealing, because it would help institutions that are risk averse to address some of the risks that are linked to the uncertainty and unpredictability of fair use analysis, and would also enable them to cut the cost of implementing a fair use analysis in each and every case. So On the one hand, this would offer a practical solution, but this practical solution of using systems would not compromise the dynamic nature of fair use and fair dealing by still enabling these systems using machine learning to adapt the algorithm to new cases. The big challenge, as I see it, is a challenge in developing new ways of thinking about the legal oversight of algorithms of that sort. But that is a challenge that copyright law share with other disciplines and other fields of law that are increasingly shifting to algorithmic decision-making. And what is really interesting in this challenge is that it is a challenge not only for engineers and computer scientists, but basically for lawyers. And that's an exciting, I think, challenge for lawyers to think in an innovative way about a doctrine that is implemented by code and about the way in which the law can evolve in order to enable it. Thank you.